Thank you. Again, my name is Amish Vaidya. I'm the Southwest Regional Director for AAHOA. And the next person that we have has such a large list of accomplishments. I have to read this from a piece of paper. It's my pleasure to introduce today's speaker. Vanessa Patel is an employment law attorney and counselor with Ogletree, Deakins, an international employment law firm in Tampa Bay. She grew up in a family of small business owners and is keenly aware of the unique issues business owners face. Vanessa has been selected as a rising star by super lawyers, an honor reserved for those lawyers who exhibit excellence in practice. If you'll join me in giving a warm welcome to Vanessa Patel, please.
Hi, everybody. I hope everybody's doing okay today. I'm more of a walker whenever I present, so I'm going to be walking around a little bit. If at any time you guys can't hear me, let me know. We're going to go through a lot of stuff today. I'm going to talk to you about 5 ways to lawsuit-proof your HR. So we're going to be talking about a lot of different employment claims, employment lawsuits, statutes, all sorts of stuff. There's a lot of topics. There's so much to cover here. I'm going to try to go through it as quickly as I can and get through everything as diligently as I can. If at any point you guys have questions, feel free to answer them. I'll try to answer them to the extent that I can during the presentation. Otherwise, we can keep moving through. So the way that we're going to do the presentation today is I'm actually going to walk you through real life situations, real life case scenarios. And we're going to take a look at them. We're going to look at the facts. We're going to look and see what the employer did, usually a hotel. We're going to see what the employees claimed. And then afterwards, we're going to debate to see who you think should win and who actually did win. And then after that, we'll talk about what the key takeaways are for each of you so that you can avoid being in this type of situation. So let's start with our first scenario. So this has to do with the Fair Labor Standards Act. How many of you think the FLSA applies to you? Raise your hand. Okay, if you're an employer, then you should have raised your hand because this applies to every single employer. This regulates the way that you pay your employees. And as you'll see when we go through some of these scenarios, your failure to comply with this can lead to tremendous damages. So let's go through this scenario. We have a housekeeper. She's alleging that the hotel that she works for forces her to work in housekeeping, which is what she's hired to do. But then after her shift as a housekeeper ends, they're making her work on the front desk. She's claiming that she's working 53 hours per week and she's never paid overtime. And as you guys know, if somebody works more than 40 hours a week, you're required to pay them overtime, which is time and a half for every hour over the 40 hours. So she's claiming she's working 53 hours, never paid overtime. She says that the hotel requires her to keep her time by using a punch clock, which a lot of people do. You have a little machine, you go and you punch in your time. And so she says she does that at the beginning of her shift. But then once she reaches 8 hours, the hotel, the employer, is forcing her to clock out, but they're forcing her to keep working. That's when she says, now all of a sudden they're making me work as a front desk clerk and I'm working off the clock. This is what the hotel says. The hotel says, no, we hired her as a housekeeper. She's only working as a housekeeper. We've paid her for all the hours that she's worked. In addition, she's taking all these long breaks. We don't document it. We haven't written her up about it, but we know that she's doing it, and we're still paying her for all of that. The only thing we have to show as to how many hours she's working, though, are her time cards. And yeah, these are her time cards. All the time that's listed on there, that's all the time that she's working. She's not working off the clock. We're not making her work as a front desk clerk. That's all the time that she's working. But the only documents we have to rely on are the time cards. We don't have any other documents. So the housekeeper sues her employer, the hotel. She's claiming 6 figures. Before we talk about who ends up winning, the employer or the hotel, some of you are probably asking, how in the world is a housekeeper that makes $4 a room or something like that, how is she suing for 6 figures? How is she asking for over $100,000? This is how you get there under the FLSA, and this is why it's important to you. When you sue under the FLSA, so she's suing here claiming she worked overtime, wasn't paid for it. That's time and a half. The part of her 6 figures, that was her wages, in this case was about $25,000. She took the 13 hours every week, multiplied that by her overtime. She said she had been doing this for a long period of time. She came up with $25,000. Under the FLSA, most employers then will be liable for liquidated damages. Liquidated damages are double. So her $25,000 in wages now doubles, and she has $50,000 in wages, and that's it, just wages. In addition to that, most employment statutes, including the FLSA, require the employer to pay the attorney's fees that the employee incurs if the employee ends up winning. Now, this is just a one-sided thing. If you go to trial on your case and you win, she doesn't have to pay any of your attorney's fees. You still have to pay your attorney, but if you lose, even if she recovers $1, even if the jury thinks that she wasn't paid $10, you have to pay all of her attorney's fees, and that's what gets really expensive. On average, to take an employment case to trial, that's going to run you $150,000 to $175,000, and you're going to have to pay all of those fees if you end up losing. So let's go back to the scenario. Who do you think won in this case, the employee or the hotel? Employee? Anybody think hotel? Well, this was actually a jury trial, and the jury found for the hotel. The reason this was so interesting is because there's about 3% of cases actually go to trial. 97% of cases these days settle. So it's interesting whenever a case actually goes to trial to see how a jury looked at this and what they thought of it. The reason that they found for the hotel in this case is because they found that the hotel was more credible. At trial, they asked this lady, you remember she said that she was hired as a housekeeper, then she was working as a front desk clerk. The attorney for the hotel asked her basic questions about a front desk clerk. She couldn't answer any of them. The jury knew automatically that she wasn't actually working as a front desk clerk, so it helped them there. But this is a one-off case. Most of the time, just like you guys had the instinct, the hotel's going to lose this type of case. And the problem is, they won in that they didn't have to pay the plaintiff, the employee, they didn't have to pay her attorney's fees, but they had to pay their attorney's fees, and their attorney ended up spending 6 figures just defending them in the case. So it was a win, but then it was also a loss in certain ways. So now we're going to move on to the next statute, the ADA. This is the Americans with Disabilities Act. I'm sure a lot of you are familiar with it, and you've heard about the drive-by plaintiffs, the individuals that drive by your property. They don't actually ever stay at your property. They might not even step foot on your property. They might not even go in the door, but they see something wrong, maybe in the parking lot. Sometimes maybe they've gone in, they see something wrong in the front desk area, and they file a lawsuit. So this gentleman, John, he's a paraplegic, and he's required to use a wheelchair just to get around. He says that he tried to enter the hotel, but he couldn't because the security sensors at the entrance and the exit were not wide enough for his wheelchair to pass through. And in addition to that, as he's trying to jam his wheelchair through the security sensors, he says that the security sensor bends the left footrest of his wheelchair, causing a severe left tibia fracture. John sues the hotel in January. A few months later, in about April, the hotel decides, you know, I think this isn't compliant with the ADA, so I'm going to make this change. So they change the security sensor, they move it out of the way, and they measure it and make sure that now it's compliant with the ADA, wheelchair can get through, but there's still this lawsuit pending. So who do you guys think wins in this situation, John or the hotel? John? Anybody think the hotel? Just a few? The hotel. This is another one-off case, but it's important because this is a way that you can defend these cases depending on what they're claiming is the issue at your hotel and whether it can be fixed. But this is what the court found. The court found that by fixing the problem, the issue was moot. So there was no problem. He didn't have any damages anymore because now he was able to fully access the property. His wheelchair could completely fit through, the sensors were wide enough, he could get in there. The hotel fixed the defect so John no longer had standing to file a lawsuit. But you see that but down there, and that's because this is a one-off type of case. But it is a defense that we've been using a lot more in these types of cases and that a lot of courts are looking upon fondly. The thing with the ADA is there's been so many lawsuits under the ADA recently. It's not going to change anytime soon. It's an area that plaintiffs' attorneys see as an easy way to make money. Like I said, they have these serial plaintiffs. This is all that these people do. They just go around to different properties. Anything that if they drive by a property and they see anything in the parking lot or anything on the structure that they think, oh, this looks like a violation, they're going to go inside and find even more violations, and then they're going to file a lawsuit. They send the information to their attorney probably spends like 20 minutes putting together a complaint, and they file it. These people are filing like 20 or 30 lawsuits a day. I mean, it's insane how many lawsuits they're filing. Nothing's going to change until the ADA, until the regulation itself changes. And so until that happens, what can you guys do? There's a few things that I've had people do, especially if you're in an area. There's a city, I'm from Florida. There was a town in Florida where one of my clients, all the other properties around him had started getting lawsuits. So he knew he was next. So he called me and he said, what can I do? I know there's the same attorney, same plaintiff in the same cases going around suing every single one of them. He's like, I know that I'm a sitting duck. What can I do? So I put him in touch with a company that can come out for not very expensive. They'll come out, they'll look at your entire property, they'll look wherever you want them to look, and they'll tell you whether or not you're in compliance with the ADA. After they do that, they'll tell you how much it's going to cost you, if they find any issues, how much it's going to cost you to fix it and to become compliant. He did that, there really wasn't any issue. I mean, he never got a lawsuit, probably because the plaintiff went in and saw that there was nothing there for him to sue, so he was okay. That's one thing you can do, is try to be proactive and make sure that your property is compliant so you don't have to worry about this. I have some clients that are DIYers. They like to do it themselves, and they like to try to fix these problems on their own. The ADA actually is not that difficult to read and to understand. So if you wanted to look it up, it's very specific as to how much space you need to have from the middle of the toilet to the wall, and how far apart your towel holder should be, and what you have to have under the sink to make sure it's covered, because you have to have covering over the plumbing under the ADA. You can't have it open, because if somebody in a wheelchair tries to pull up to it and their legs touch that area, that's a violation. So you could try looking at the statute yourself, but the better option would be to try to hire one of these local companies to come out and just do a check and make sure that you're compliant. If you do get sued, though, make sure that you hire somebody to represent you that knows what they're doing. The thing with ADA settlements, I had a client that got sued for an issue in his parking lot. The plaintiff's attorney and his attorney came to a settlement. It was probably a few $1,000s. I mean, it was more than he wanted to spend, but he said, I'm just going to settle this. I don't have to deal with it anymore. I'm going to be done. So he paid this guy off. Fine. 2 months later, he gets sued again. Same person, same everything, same allegation in the parking lot. This guy had never fixed the issue, and the guy came back and sued him. And so he goes to his attorney and he says, we just paid this guy 2 months ago. Why is he suing me again? The plaintiff's attorney says, I never signed anything saying that I'm not going to sue you again, so I can sue you again. The problem's still here. So he got sued again. He paid him again, not as much, probably about half. And guess what? 3 months later, this time he signed something and it said, I'm not going to sue him again for the parking lot. Months later, he gets sued again. Now the guy went inside his property and found an issue inside one of the public bathrooms. So he got sued again, and then he came to me. And if you settle one of these lawsuits, you need to have a settlement agreement, first of all. You need to have the person that you're paying money sign off on something saying you've paid them money for this, and you need to have language in there that says, I, the plaintiff, agree that I see no other violations at this property. Then you're covering yourself. Sometimes you can go even broader, depending on whether or not the plaintiff's attorney is looking at this agreement that closely or not. You can try to go broader, especially if you own different properties, and try to encompass other properties and say, this plaintiff doesn't see any violations at any property owned by, and then you list your parent company there. And now you've protected yourself at all your different properties, especially if they're in the same area, because what you'll see with these lawsuits is it's one plaintiff that's going around, and it's always in the same area. They're going around to all the hotels in that same area, so if you have multiple properties and you've protected yourself with that type of language, they're not going to be able to come and sue you at those other properties. Do you guys have any questions about the ADA before we move on?
I had a different question.
Okay.
What about the liability insurance we have? Does it pay
The liability insurance do you have property liability insurance or EPLI?
the property liability?
Property liability insurance won't cover that. There's usually an exclusion in your insurance policy. You can look closely, but almost every insurance policy that I've seen has an exclusion for these types of.
What should we look for?
What can you do?
What should we look for to
Look for?
encompass?
Insurance companies won't cover it. It's gonna be very rare that you're gonna find an insurance company that's gonna cover something like this. Yeah.
I thought with the revised ADA, there was some language about like having 90 days to fix these issues or complaints.
No, there's talk about having that, but it's not in there yet, and the plaintiffs are not required to give you notice before they file a lawsuit. There are some jurisdictions that are changing that. They're trying to change it. In Florida, for example, where I practice, if a plaintiff files a lawsuit, most of the judges automatically stay the case for a certain amount of time, so you can try to work with them and negotiate something. Because this is one of those statutes where they can recover their attorney's fees, and what you don't want to happen is that the person is running up the attorney's bill, and then you're gonna have to pay even more. So the court will stay the case that you don't have to take any legal action. All you're trying to do is resolve the issue that's going on at the hotel. If you guys have more questions, I'll talk to you guys afterwards. I wanna make sure that we get through everything. This is the next scenario. It has to do with the U.S. Department of Labor. So we have a hotel that uses a staffing company, and they use them to staff certain positions in their restaurant and the banquet, like bus boys and cooks and dishwashers. So the staffing company says to all these people whenever they hire them that you're an independent contractor, and they have them sign this agreement that says independent contractor in bold language, right on top, caps, right in the middle, and they say, by working for us at this hotel, you agree that you're an independent contractor and you're not an employee, and it's a very long, detailed agreement. The individuals, though, feel like they're actually employees. They're not independent contractors. And so they complain to the Department of Labor. The staffing company tells the Department of Labor, they've signed these agreements. I don't know why they think that they're employees. They signed all these agreements, and also we pay them as 1099s. We don't even pay them as W-2s. The employees, though, say, well, we signed these agreements, but we go to work there every day. We're working right alongside all of these other employees that are employees of the hotel or the staffing company. We all wear the same shirts. They all have like the hotel's name on it. They're telling us what to do, how to do it, when we should be there, all of that. So who do you think wins in this between the staffing company and the individuals? Do you think that they're independent contractors or employees? Employees? So you guys were right. The Department of Labor found that they're all employees. One misconception is if I label them as an independent contractor, they are an independent contractor, and that's not the case at all. Neither the Department of Labor or any court will look at a document as being definitive of what their position is. They're actually going to look at what these people are doing, what they're doing day to day, what positions they hold, and what the key is how much you control and you supervise these people. If you're controlling and supervising any individuals at your property, you are going to be deemed an employer. And that brings us to, well, first of all, the Department of Labor found that there was almost $100,000 in overtime due to the individuals. So the next question is, who had to pay that? Was it the hotel or was it the staffing company? You think staffing company? Some people think hotel? Both. The staffing company ended up having to pay more, and that's because the Department of Labor thought that their conduct was more willful. By making these people sign agreements that say independent contractor, knowing that they weren't independent contractors, they felt like their conduct was egregious enough to where they needed to be penalized more than just the hotel that really didn't have anything to do with this aside from being a joint employer. And that's the key here is the staffing company and the hotel were both deemed to be employers. A lot of people think, how many people in here use staffing companies? Not just 1, 2, 3? So some people think that if you have a staffing company, you have insulated yourself, that now these aren't your employees, there's staffing company's employees, the staffing company is just bringing them in, and you're not going to be liable for anything, and that's 9 times out of 10, that's not the case. If you're there on staff, you're on site, you're supervising them, you're telling them what to do, they're going to be deemed your employee, and you're both going to be liable. So this is what the Department of Labor had to say about this. Staffing agencies and their employer clients, so that's the hotel and the staffing company, share responsibility to ensure that all employees working on their behalf are paid the wages they are entitled to by law. These violations are all too common in the hotel industry. And our agency will do everything in its power to end the willful misclassification of employees as independent contractors. This is putting you on notice that this is one of the things that the Department of Labor is really looking for, and it's one of the things that you want to avoid. And there's two issues here as far as misclassification goes. This is one that we talked about, misclassifying employees as independent contractors. I don't know does anybody in here have any independent contractors that they use? If you do ever do that at any of your properties, make sure that you're doing a legal assessment to determine if they actually are independent contractors, because if they're not only can you get fined by the Department of Labor, but this is a tax issue too. And the IRS and the Department of Labor will work hand in hand to make sure that you've paid all the penalties you were supposed to, because by misclassifying somebody as an independent contractor as opposed to an employee, in the IRS's eyes, you are, what is that?
What if they are working at two different places, part-time at your place and part-time at other place?
Do you own both places? Do you own both the? It's completely two different companies. Is that right?
Yeah, it's two different companies and they go to the different location, perhaps the
If there's common ownership, then you're going to have to make sure that they're not working overtime, and you're going to be deemed an employer for both locations. So if somebody's working 40 hours at one location and 40 hours at another location, you're going to have to pay that extra 40 hours of overtime. It's not separate locations.
they work 30 hours at one place and 10 hours at another.
Yeah, it's only going to be an issue if you have common ownership. If there's no common ownership, then it's not going to matter. The other area of misclassification that a lot of hotel owners run into is misclassifying individuals as exempt from having to pay overtime. So if you have a lot of people think that if they put an employee on a salary, then they're exempt and you don't have to pay them overtime, and a lot of times that's not true. There's a two-part test. So to be exempt under the Fair Labor Standards Act, you have to pay them a certain salary, and in addition to that, the employee has to perform certain duties. And the duties that they perform varies depending on what type of exemption you're trying to claim, but you have to make sure that you're meeting both of those tests, because otherwise they're not going to necessarily be exempt just because you pay them a salary. That's not the end test. So let's go on, let's talk a little bit more about overtime and look at another case. So now we have a front desk clerk. She's scheduled to work an 8-hour shift from 9 a.m. to 5 p.m. She regularly clocks in at the beginning of her shift, right at 9 a.m., but every day that week she clocked out at 6 p.m. She didn't have authorization to work overtime. She just said that she was there the extra hour because she was helping a guest with an issue. But all of her coworkers say she wasn't really working after 5 o'clock. She was just socializing with the guests, but she just didn't clock out for another hour. So her timesheet that week shows that she worked 45 hours. Does the hotel have to pay her for that extra 5 hours? Does anybody think that they don't? Yes. If an employee, regardless, if they don't have authorization, you can write them up, but you have to pay them if they work that time. And that's the key, is if they didn't work that time and you can definitively show that they didn't work it, then you don't have to pay them. But it's so hard to get to definitively. In this case, they didn't know for sure what she was doing. They didn't talk to the guest. By the time the employer saw this on the timesheet, the guest had already checked out. They had no idea if she was actually helping them or if she was socializing like the coworker said. And because they couldn't definitively say that she wasn't working, they had to pay her that extra overtime. But all of you should have a policy about overtime. And your policy should state that you have to have prior authorization and prior approval before you're allowed to work overtime. And in that, you should indicate who can give authorization. It shouldn't just be a blanket, you need to get authorization. It needs to say, you need to get authorization from this person or these people, and you need to list them by name. You shouldn't just leave it open-ended. And if they violate that policy, you should write them up every single time. Don't let it go, and definitely don't overlook it. Here are some examples of off-the-clock work that people don't think about that occur a lot in the hotel industry. Any time that somebody is doing work for you, they need to be on the clock. If it's a salaried employee, it's a little bit different because this type of stuff is kind of built into it. But if it's an hourly employee and they have to use a computer, for example, if they have to use a computer for their job. The time that they spend turning it on and turning it off, you might just think it's minutes, but those minutes add up if they're doing that all that work off the clock. And then of course you could be liable for liquidated damages, then you have to pay double and you have to pay all their attorney's fees and all that, so it gets expensive. If it's somebody that's supposed to check emails for work, and they're checking them at home or they're checking them on their phone on the way back and then they're responding to emails, all of that time has to be paid. That's all compensable time that you need to make sure that you're paying them for. You have to make sure that you're giving them an uninterrupted lunch break of 30 minutes. If you're not, that's going to be compensable work time. Again, making phone calls, housekeeper, this comes up a lot. People have their housekeeper get their carts ready, put all the towels on there, put all the laundry on there, get ready to go before she actually clocks in. That you have to make sure that all that work that she does is after she clocks in. It all has to be on the clock. So now we're going to talk about harassment cases. Have any of you guys had to deal with a harassment or discrimination or retaliation lawsuit or an EEOC charge? Yeah? Okay. So I'm going to give you two actual lawsuits. This is the first one. I'll give you the second one in a second. And I'll tell you that out of these two, one of them got dismissed by the court. The court looked at all the evidence and said, employee, you have no case. I'm going to dismiss this case. The second scenario, though, in one of these two, it went to a jury, and the jury awarded a lot of damages to the employee. So I want you to try to figure out which one's which one the employer won and which one the employee won. So this is the first scenario. The supervisor asked two female employees inappropriate questions on a number of occasions. He pulled down his pants and he exposed himself on more than 2 occasions, and he offensively touched the female employees on several occasions. The employer didn't deny that any of these inappropriate actions took place. This is the second lawsuit. It's completely separate. Male supervisor made 4 sexually inappropriate comments to a female employee over a period of 6 months. On one occasion, the supervisor slapped the employee's buttocks with a belt, while another supervisor observed and laughed. The supervisor denied making some of the comments, and there was evidence that the female employee was not offended by the comments. So out of these two, how many of you think that in this lawsuit, they found for the employer? How many think so everybody thinks that they found for the employee? What about in this one? How many of you think that this is the one they found for the employer? Just a few? You're confused? Okay. You're actually going to be surprised. So in the first one, the court dismissed that case. No liability. The second one, though, went to a jury trial. The jury found in favor of the plaintiff, the employee, and they awarded almost $7 million in punitive damages. Punitive damages are damages that are above and beyond so you typically have compensatory damages or punitive damages. You only get awarded punitive damages if the jury thinks that your conduct was so bad that it needs to be punished above and beyond just typical compensatory damages. So in this case, they awarded $7 million in punitive damages. So what's the difference between these two? Does anybody have any ideas? So if you look at this one, this is one supervisor. The way that the employer phrased all of this to the court is that this was a rogue supervisor. This wasn't a supervisor that was following any of our policies. And by the way, we had a policy against sexual harassment. They had this long policy in their employee handbook, which all of you guys should have a sexual harassment policy in your employee handbook. But the policy said generally what your policy should say. We don't condone, we don't approve sexual harassment in the workplace. These are examples of sexual harassment in the workplace. If you feel like you've been sexually harassed, or if you witness sexual harassment, report it to your manager and then up the chain. If it's your manager, for example, that's the one that's doing the sexual harassing like they were in this case. And they had this entire policy. And the employee actually took advantage of the policy and she complained. And that was when she complained was the first time that the employer found out that this was even going on. And as soon as they found out, they fired this employee. That was key in this case. They fired the supervisor. The employer didn't know anything about it. The other key to this case is it didn't occur for a long period of time. You might remember in the second lawsuit, that went on for 6 months. For for something to rise to the level of sexual harassment, you typically need something that's ongoing for a long period of time. It can't be something that just happened once or twice. It has to be something that's, in the legal term, severe and pervasive throughout the workplace. In this case, the other key was, in addition to it being 6 months, there was this other supervisor that knew about it, that was participating in it. And the jury found that to be severe and pervasive across the workforce. Now you don't just have one supervisor that's been doing this, not even for a short period of time, but for 6 months. You have a second supervisor that knows about this stuff, and because of all that, they punished the employer with $7 million in punitive damages. So what can you do? Have policies in place. The other thing is, I have a lot of clients that have these policies in place, but their managers don't even know what the policies are. Your policies are no good if your employees don't know what your policies are. And if your managers don't know about your policies, your employees are very unlikely to know what they are either. Your managers are the ones that are going to be in charge of enforcing your policies. So if you're not training them to know what to do, what not to do, especially in these types of situations, and what to do if somebody comes to them and reports one of these types of situations, these situations will go on in your workplace and you won't even know about it. So you just need to make sure that you have the policies in place and that everybody knows and it's communicated effectively throughout your workforce. So let's talk a little bit about the most common reasons that we see employers getting sued. And a lot of this has to go with just basically treating your employees fairly, being honest with them, having open communication. That's going to be key in your workplace. Failure to communicate job expectations or requirements goes hand in hand with failure to give notice whenever employees are not meeting them. I do a lot of training for managers, and I can tell you managers always tell me, oh, it's such an awkward conversation. I don't want to talk to somebody if they're not doing well. Like, I'd rather just, maybe they'll just get better. And I just don't like sitting down with somebody and talking to them. That's the worst thing that your managers could do, to just have a bad employee. Not only does it hurt your bottom line, but it's going to hurt you in the future whenever that employee's performance gets worse and worse and worse to where you need to terminate them, but you don't have any documentation to support that. You need to make sure that whenever an employee has any sort of performance issue, if they're late to work, if they're not showing up, they're not doing what they're supposed to when they're there, any type of issue like that needs to be documented immediately. And as you're documenting it, what goes hand in hand with documenting it is talking to the employee about it. Your documentation is not going to be very helpful if the employee has no idea about why you're writing them up. You need to sit down, have a conversation with them, do it in a private place because nobody wants to shame these employees or embarrass them. But have a conversation with them. Have a one-on-one conversation. Hey, you've been late multiple days this week. What's going on? You're typically a good employee, but this week you've just been late and we don't know why. That person might have some sort of personal problem going on that's a temporary thing that might just last that week, and you think, okay, well, this will get better. You're still going to write them up for it, but at least now you know. Now you've talked to them, and employees feel what we hear over and over again from employees. They think that if you don't talk to them about these things, one, nothing's going on, and two, that they're doing great. If you don't communicate these things to them, they a lot of times have no idea that you're unhappy with their performance. And then whenever you fire them, they're going to start thinking, well, why is she firing me? It must be because I'm fill in the blank with some protected category. So you want to avoid that. Just be open and honest with them. And during the meeting, give them an opportunity to defend themselves. Give them an opportunity to explain why it is that they're having performance issues. The other thing is you need to make sure that you're consistent with your performance and your disciplinary actions. Don't treat people differently. If two people do the exact same type of thing, let's say you have an employee that you have a gift shop. This actually happened with one of my clients. She called me and she said, hey, I have this employee. She stole from the gift shop. And I said, well, how do you know that? Another employee saw her stealing. She had put this stuff in her bag. They had a gift shop by the front desk. She said another employee saw her go in there and steal some candy. She put it into her bag and, So then I asked my other employees too. I said, have you guys seen this happen before? And 2 or 3 of them said, yeah, I've seen it happen before. I just thought maybe she had paid for it or I I don't know. I just didn't want to say anything because I felt afraid to say anything. So she calls me and says, this employee I know from various employees, she's been stealing from me. Can I fire her? I said, well, 3 months ago, you called me and you told me that you had a maid that stole a bottle of water, but you felt bad for her because it was hot outside that day and she'd been outside doing some work. And so you let that go and you just wrote her up. You know that this is going to be different treatment because what you're going to do is you wrote her up under your theft policy, and now you're going to fire somebody else under that same theft policy. That's unequal treatment, and that's going to open you up to a lawsuit. So you just need to make sure with any disciplinary actions that you take or any terminations that you decide to go forward with, that everything that you're doing is treating everybody equally. So let's fill in some blanks here. And we've talked a lot about documentation and the importance of documentation. This is based on a survey of jurors that were asked how important documentation would be to them when they're sitting on a trial in an employment lawsuit. The three of these don't add up to 100%. They were all individual questions, so they could be anywhere from 0 to 100%. So what percent do you think say the best evidence of work performance is in employees' evaluations? You guys think like 20%? Higher? 50%? 60%? 70%? 80%? You think it's the biggest one? It's actually 61%. 61%. It's actually, well, I won't tell you where it falls with the rest of these. We'll get to that. How many people do evaluations for their employees? So maybe like a third of you guys. This is something you need to be doing because now you see 60% of jurors want to see that. What percent do you think that the company is negligent if it doesn't document performance problems? 80? 90? Lower, higher? Lower? 50%? 91%. 9 out of 10 people. If you have 90% of your jurors that already think you're negligent, you're not going to win that case. It's going to be impossible for you to overcome that and get over that. So you have to make sure that you're documenting the performance problems. So what percent of employers do you think, I don't think that they should be able to fire anybody right away. They have to give them a warning at least first. What percent of jurors do you think are in that mindset? 100? 74%. 3 out of every 4. So 3 out of every 4 people think, generally, you need to give them a write-up first. I don't care how bad that employee is doing for you. I don't care how much it's affecting your bottom line. You have to write them up first. Otherwise, I automatically think that you're doing something wrong.
I have a question. In the case of that lawsuit number 1 that you talked about, right? In that one, the supervisor was fired immediately or he was given a warning?
No, he was fired immediately.
So why do you say that mindset is inappropriate?
That was a different scenario. So there's that 25%, there's the 25% that realize that you don't always have to give a warning first. And in situations like that, or situations where you have a clear theft or something else that's so egregious that justifies a termination right away, jurors typically are going to be okay with that. But this is all a jury. This is all what you're going to get if you go to trial with a jury. You never really know. And most of the jurors that you're going to get on typical employment cases are not going to be business owners. They're not going to be people that think like you and me. They're going to be regular employees that give substantial deference to a plaintiff, that believe that everything that the plaintiff did was right. They give them the benefit of every single doubt. And if you're not documenting what you're doing, they're not going to be in favor of you at all. And that's what we can see with these numbers.
Then I have a question. Then what is the role of the jury selection? Are you going to select those kind of and put all of them on the jury?
No, but I'll talk to you about jury selection later. That's a whole nother, I could talk to you about that for an hour. So let's talk about the 5 most common types of evidence that's used against employers. And you'll see a common theme here. These are all documents. These aren't words that you said. These are all words that are written. Performance reviews, job descriptions, written policies, documentation, having too much or too little. Offhanded, insensitive comments. These are the types of documents that get used against you. So on one hand, I'm telling you, make sure that you document, make sure you do all this stuff, but on the other hand, I'm telling you it's getting used against you. You know, you're probably thinking, what's the catch? What can I do? How can I even win? Just make sure that whatever you're writing is honest. If you're giving somebody a performance review or if you're writing them up, make sure it's honest. I mean, a good rule of thumb that you can tell your managers is everything that you write down, you want to be able to explain that with a straight face to a jury. You want to be able to explain to them why you wrote that down, why that mattered to whatever it is, whether it's a performance review or a written disciplinary action, and that's it. If you can explain it, then it's fine. If you have things that are listed there that you can't explain, offhand comments that aren't relevant to anything, then you're going to have issues. And if you have one document that's called into question that people feel is untruthful, all of your other documents are probably going to be deemed to be, they're in the same category then. Nobody's going to believe those other documents that you have. So these are, the last thing I'll leave you with is some preventative measures to try to avoid claims. Accurate employee evaluations and document every single thing that goes on in your workplace. Employee handbooks and manuals. If you don't have an employee handbook, you need one for your workforce. Every time you hire a new employee or you update your employee handbook, make sure that your employees sign something acknowledging that they received a copy of either the initial or the updated handbook. And then also make sure that they acknowledge that they understand it and they received it and all that good stuff. Investigate before you terminate. Make sure that you have equal treatment for terminations. And think about considerations before you terminate somebody. Think about whether you're treating them all equally. Did somebody else do the same stuff and they weren't terminated? Did I treat somebody else differently? Yes or no? If the answer is yes, I did treat somebody else differently, you better have a very good reason to justify why you're treating these people differently. Investigate before you terminate. In the case that I gave you earlier about the theft, I told my client, before you terminate this person, you need to get written statements from all of her coworkers that have told you verbally that she stole stuff. Because what happens a lot of times is the person gets terminated. It might be months, it might be a year before you hear anything from that person's attorney if they're going to file a lawsuit against you. And at that point, those people that told you back in the day that this person stole, they may not be working for you still. And if they are working for you, maybe they don't remember. That's going to hurt you in the long run. But if you have a written statement from those people at the time that these things happen, that's going to help you. That's going to help them remember what it was that happened at the time. And just make sure that you're completing an investigation. You're doing a thorough investigation, which would include talking to the employee that's accused of doing something wrong. So I told my client, you need to talk to her and ask her why she was taking these things, or confront her and tell her, you know, all of your coworkers have told me that you've been stealing stuff and this is what they've said and here are their statements. What do you have to say about that? She may have a legitimate explanation. Probably not, based on what my client told me, but you never know. But you need to give them the opportunity to do that, and you need to complete your investigation and have findings from your investigation. And then document all that, keep it in their file, and keep it in case you have a lawsuit. And this will help you a lot in the long run. It'll help you gain favor with a jury if you end up going to that point, or it'll at least help you gain favor in front of a judge that'll look at your case and hopefully dismiss it beforehand, like we saw with the first lawsuit with the sexual harassment stuff. So now we have time for questions. Does anybody have any questions? Sure.
If we are the employer, like if I have a company and I have a management company who's managing my property, but the employees are under my company's name, who's liable?
The management company or you? It depends. If you're controlling, if you have any supervisory duties, if you're controlling, or anybody, any of your managers.
I mean, the management company has the full authority, but the employees are on our company's name. So is that liability?
Yes. So he's asking about management companies, that he has a management company, he doesn't control these employees, but he pays the employees. He's listed as the employer on the paychecks. You could be a joint employer because of that. Because in the employee's mind, when they get a paycheck and it has your company's name on it, that's who they think is their employer. That's a problem.
Vanessa, I apologize. Let me interrupt for just a second. You can still ask questions afterwards. There's a couple of housekeeping notes. We have the women's conference starts at 4:30. So I'm going to let the women that need to go to that go. But before you leave, please give Vanessa a big round of applause. And I also want to give her a little gift from AAHOA. Now we know why she's a rising star or a superstar with the super lawyers in America. Thank you so much. Those of you that have questions, please stay. You can ask questions all you want. The one I have for you, you've learned a lot in this session from Vanessa. You may have learned something from the previous session. When you get back home, implement whatever you learned. It does no one any good if you sit there and keep it in your head. So thanks for coming. Whatever questions you have, we'll go back to Vanessa. Thank you.